Well, good afternoon, everybody. Bill O'Leary coming to you, a Legacy Planning Law Group on this Thursday, the Thursday before Easter. For some of you, Holy Thursday. So I want to wish everybody in advance a very happy and blessed Easter Sunday. So we're here as part of our Thirsty Thursday series, and so for those of you that maybe not have not participated before or listened before, it's a series that whereby every Thursday at about this time I come live and talk about a different topic that at least relates to what we do as a law firm: estate planning, wills, trusts, and estates, elder law, basically estate planning for our seniors, and then sometimes talking about sort of dealing with somebody's estate after they die, what we call probate, or administering an estate or a trust. So, if you're thirsting for knowledge as part of this Thirsty Thursday series, you have come to the right place. Today's topic is, what can I do if someone will not honor my power of attorney? Okay, and we see this unfortunately more often than you'd like to think. So, what is a power of attorney? A power of attorney, sometimes called a POA for short. It's one of the most commonly used legal documents because of the many different sort of purposes that a POA can serve. So basically, a power of attorney or a POA, it's a legal agreement where somebody grants somebody else authority to act in legal or financial matters. If you are the one that signs the POA, you're called the principal, and the person that you are giving authority to is called the agent. So typically a POA is going to authorize the agent to do things like, withdraw money from bank accounts, maybe enter into a contract, maybe even sell assets, on behalf of the principal, maybe, enter into a loan, those sorts of financial type transactions. Now, a POA is sometimes called a durable power of attorney, a durable POA. What does the word durable mean? You ever ask yourself that? What does the word durable mean? It simply means that the authority that you have given to the agent, that authority is not going to end or stop at the point when you become incapacitated. But instead, that authority is going to continue. It's going to continue beyond that time when you become incapacitated. So it's durable. It continues on. And that's really what you want. You want a durable power of attorney. Okay? Now, given how often POAs are used, you'd think that the authority that an agent is given under a POA is never questioned out there. You would think using a POA should be relatively simple. Well, at least in theory, it is. Since a POA gives the agent the authority to act on behalf of the principal, again, you would think pretty straightforward stuff. All the agent needs to do is to provide a third party, such as, let's say, a bank or a financial institution, provide them with a copy of the POA with proof that they have been given this authority by the principal. Just present the POA, maybe even having to present the original. That's okay too. And once that's done, then the agent is sort of off to the races and able to exercise the authority given to the agent under that power of attorney. However, oftentimes it's not quite that easy to use the authority granted under a POA. The truth is that financial institutions have been known to refuse to honor the authority of an agent under a POA. Banks, credit unions are notorious for refusing to honor a POA, or at least, they're going to question the POA when they're presented with it. So, look, even though the POA may clearly grant this authority to the agent, again, banks especially and other financial institutions sometimes will refuse to honor it. So, what are some of the most common reasons why a bank or financial institution will say, no, we're not going to honor it? Well, one reason they give is, well, the power of attorney is stale. It's too old. Common excuse, okay? Oh, it was executed a long time ago, so it's not good anymore. Well, under the law in Florida, that is not a valid reason for saying no, okay? Now, that said, when given a no answer, you can pound your fist on the table and say, but you know, the law in Florida says that you can't, that's not a good reason. Well, you can fight that fight, and it's going to then involve the bank's legal department getting involved. Or if you have an old POA, why don't you just sign a new one and be done with it? That's usually the easiest solution to a POA that is has some years under it. Second reason that we see is the POA is not in a proper form. Okay, the financial institution will say, oh no, we're not going to accept your form of the POA. You have to sign our form. Now, legally, the financial institution is not allowed to say that, is not allowed to do that. They have to accept your form of POA, assuming that it's otherwise a valid form under the law, and they cannot force you to sign their form. Now, again, that's the legal answer I just gave you. But sometimes it's not worth the hassle to sort of fight the fight with the financial institution. Sometimes it's easier just to go ahead and sign their form that they give you. You still have your own POA to use for other purposes with other institutions. Of course, before you sign any form that the institution gives you, you should have your estate planning attorney review it first before you sign it. A third reason that we tend to see is, you haven't given us any proof that the principal is incapacitated. So again, it's the agent that walks into the bank, and the bank says, well, we're not going to honor this because you haven't given us proof that the principal, the person that appointed you, you haven't given us proof that they're incapacitated. Okay? Well, so let's talk about it. What does that mean? Well, some POAs, especially older ones in Florida, or maybe POAs that were done in another state, are a special kind of POA called a springing POA, a springing power of attorney, which simply means that POA will become effective only if and only when the principal becomes incapacitated. Because think of it as if at the time of incapacity, when the principal becomes incapacitated, the POA springs to life. But before that time, it's not in effect. So, with these springing POAs, if that's what you have, the institution may question whether incapacity exists. So in that case, if you have that springing type of POA, often a letter from a doctor is going to be required, making some sort of determination of incapacity. Now, if you have a newer POA in Florida and it was done by a competent estate planning lawyer, especially one that was entered into after October of 2011, then chances are that is not going to be the springing type of POA, because a law went into effect at that time that eliminated springing powers of attorney. So if you have a newer POA within the past 10 years, you're probably not going to encounter that as an excuse, or at least you shouldn't. Now, although institutions do sometimes refuse to honor the agent's authority, again, in many cases, that refusal is not legal. In Florida, the law is clear that the institution must accept or reject the POA within a reasonable time. What does reasonable time mean? Generally considered between 4 and 7 days. So if the bank's going to take longer than a week to either say yes or no, then they are sort of running a liability risk to you. And when if they say no, they have to state the reasons why. Now, the law in Florida allows the bank to state certain reasons that are going to be considered to be good reasons to say no. For example, if the institution has knowledge that the POA has been revoked, they then have a basis to say no. If the institution has a good faith belief that the POA is not valid, it's another good reason. If the institution has a good faith belief that somebody has filed a report alleging that the principal, the person that put together the POA, maybe has been exploited or abused either physically or financially, okay? Those are three sort of common reasons that are laid out in the law, reasons that the bank can use to say no. Now, if before a bank will say yes and honor it, the law also allows the institution to ask the agent to provide an affidavit that says basically the principal's not dead and this POA has not been revoked. Okay, and if after that request is made, the agent refuses to provide that affidavit, the institution then can say no, we're not going to honor the POA. Now, if you've been appointed as an agent under a valid POA, you really, would like to know whether that institution can legally refuse to honor it and under what conditions. And again, if you find yourself facing a no answer or refusal and you can't work it out, okay, you may need to seek a court order that's going to force the institution to honor the POA and your authority under it. And if a lawsuit is brought, the law allows you to collect attorney's fees if the institution is deemed to have unreasonably said no. In fact, there was a case that involved Bank of America where they refused to accept a Florida POA, where the agent was trying to withdraw money from the principal's account. The agent went ahead and took them to court, and they won a $64,000 judgment against the bank. Of course, none of us wants to go to those extremes and to that extent and have to sue Bank of America. So look, if you'd like to know a little bit more about when someone like an institution can say yes or no, and what happens if they say no and don't honor the power of attorney, and maybe if you'd like to know more about how we can help, we'd be happy to talk to you. You can go ahead and book a free 15-minute phone call, discovery phone call with our team, where basically you're given a chance to share your concern, and we can sort of start a conversation to see whether we might be a good fit. If you want to book that call, go to our Book Now button on this Facebook page, or just Google us, Legacy Planning Law Group .com. Again, it's a complimentary 15-minute call with our team. Okay? So, as I wrap up, hey, if you've enjoyed this talk, I would ask that you like the video, better yet, share it with your friends, all the better, just trying to get the word out. So again, I hope you've enjoyed this talk. What can I do when someone does not honor my power of attorney? As I said at the start, I plan on giving another a live talk next Thursday at about this time. Again, it's all part of our Thirsty Thursday series, same day and time, just a different topic, just trying to mix it up with some variety. So if you're thirsting for knowledge, you've come to the right place. So Bill O'Leary signing off for now. Again, happy Easter, and on behalf of the entire team here at Legacy Planning Law Group, go make it a great day.